From the Library of Congress in Washington, D.C.
Good afternoon, everyone. Welcome to the Library of Congress. I am David Mao, the Law Librarian of Congress, and I'm very happy that you're here to attend this Law Library of Congress sponsored event in celebration of Law Day. So Law Day is a national day to celebrate the rule of law and its contributions to the freedoms that Americans enjoy every day. Or as President Eisenhower proclaimed in 1958 during the very first Law Day, it's a day of national dedication to the principle of government under laws, and as a day of national remembrance of the great heritage of liberty, justice, and equality under the law. Can't say any more than that, right? So each year for Law Day, the American Bar Association creates a theme. And so the theme for Law Day this year is American Democracy and the Rule of Law, Why Every Vote Matters. This theme calls on every American to reflect on the importance of a citizen's right to vote and the challenges we still face in ensuring that all Americans have the opportunity to participate in our democracy. And this is really important and very timely, especially as we approach the 50th anniversary of the Civil Rights Act of 1964 this summer, and then next summer, the 50th anniversary of the Voting Rights Act of 1965. So to commemorate Law Day this year, the Law Library of Congress is very pleased to welcome Professor Jeff Rosen to speak. The title of his lecture will be The History of Civil Rights and Voting Rights, American Democracy and the Rule of Law. I think many of you will remember that Professor Rosen was on a panel that we had for Law Day last year, and so we're really, really excited that he agreed to come back and speak to us again. It was just wonderful last year, and it's going to be even more spectacular this year. Of course, I also know that Professor Rosen is no stranger. Is no stranger to any of us. He is so well known that in my introduction, I thought if I were to tell you everything about him, we would be here listening to me talk rather than to him talk. So I think I will just mention a couple of things. His biography is included in your program, of course, for more detail. As I'd mentioned, he's a professor. He's a professor of law at George Washington University. Currently on leave, though, because he has the great job of being working at, I want to make sure I get your title correct, President and Chief Executive Officer. Wow, that's exciting. At the National Constitution Center, which I told him during lunch before this program that I would mention, is an institution chartered by Congress to disseminate information about the United States Constitution on a nonpartisan basis, which of course at the Library of Congress it's very important to us that everything be done on a nonpartisan basis. Shout out to my colleagues at the Congressional Research Service. Really, there's just so much that I could tell you about Professor Rosen. He's a journalist, an author. He's written on many things, and I know all of you have read his work. So really, the only thing I want to leave with you is this quote that I saw somewhere when I was doing some background research, and it is that the Chicago Tribune has named him as one of the 10 best magazine journalists in America, and the LA Times has called him the nation's most widely read and influential legal commentator. I think that really says it all. So please join me in welcoming Professor Rosen to the podium. Thank you.
Thank you so much, David, for that wonderful introduction. It is such an honor, despite the scary AV. Can we try to fix it? Let's try that. It is an honor to be speaking to you through this microphone here at the Library of Congress. Part of our inspiring congressional mission, which David mentioned, to disseminate information about the United States Constitution on a nonpartisan basis. What an inspiring mission that is, and how exhilarating it is to be here at the Library of Congress, which shares that nonpartisan mission of constitutional education and does it so well. And we had a wonderful lunch, and I'm looking forward to our partnership on many levels, which will include our joint participation in your great celebration of the anniversary of the Magna Carta next year. So I'm tremendously honored to be here on Law Day to talk about the history of civil rights and voting acts. It's hard to imagine a more auspicious time to address this topic. As David mentioned, this is a season for anniversaries. July 2nd, the 50th anniversary of the Civil Rights Act of 64. Next year, January 31st, is the 150th anniversary of the 13th Amendment, abolishing slavery. August 31st is the 50th anniversary of the Voting Rights Act of 1965, and then for the next 5 years, we're going to celebrate the 150th anniversaries of the 14th and 15th Amendments as well. So this is an important time for anniversaries, an important time to think about the constitutional and historical roots of guarantees of equality in America. I want to use this important opportunity to explore the sources of American equality, and in particular, the heroic myth, which holds that it was the Supreme Court in Brown versus Board of Education that vindicated the promise of Reconstruction and allowed equality to flourish nearly 100 years after it was first promised in the 14th Amendment. And I want to argue to some degree that heroic narrative of judges being the primary drivers of equality is mirrored in our story about the Voting Rights Act. We look at cases like Katzenbach and Morgan and the other great cases of the 1960s, which upheld Congress's power to pass the voting rights and made its promises a reality. And we think that the great achievements for civil rights and voting rights came primarily from the Supreme Court. In my talk this afternoon, I want to argue that that conventional wisdom is wrong. I'll draw from arguments that I laid out in a book called The Most Democratic Branch, which was a little noticed classic that I wrote nearly a decade ago. It was applauded greatly by my mother, but I'm glad to have the opportunity to share with you some of its arguments. And in that book, this morning, I want to argue that the conventional wisdom is wrong, that judges are most successful in enforcing civil rights and voting rights when that consensus about equality was triggered by Congress or legislatures or both. In other words, when it comes to the expansion of civil rights and voting rights, it's been the people and their elected representatives in Congress who have led rather than followed. And from the post-war period to today, when judges have tried to impose contested visions of equality on the country by judicial fiat, they've been just as likely to thwart visions of equality as to advance it. Now, I want to stress I'm coming from the National Constitution Center, and there are good arguments on all sides of the debates about equality that have transfixed the nation since the post-Civil War period. I'm not going to favor one side of these arguments over another, but I do want to argue descriptively that history suggests strongly that when judges have struck down laws on the basis of constitutionally contested visions of racial equality, they've often been viewed, with the benefit of hindsight, as misguided judicial activists. Let me start from the beginning and work up quickly to the present so we can have a conversation about this fascinating topic. As David Rubenstein and I are arguing in a forthcoming pamphlet about the relationship between the Declaration of Independence, the Constitution, and the Bill of Rights, it's clear that Jefferson's Declaration made certain promises about which liberties were fundamental and inherent, and also made certain promises about equality, but these promises didn't become legally enforceable until they were enumerated in the Constitution and the Bill of Rights. But it took a civil war, which President Lincoln in the Gettysburg Address called a new birth of freedom, to vindicate the Declaration's famous promise that all men are created equal, and it took the 14th Amendment to the Constitution, ratified in 1868, to vindicate James Madison's initial hope that not only the federal government, but also the states would be constitutionally required to respect fundamental liberties guaranteed in the Bill of Rights, a process that didn't begin in earnest until the 20th century. After the Civil War, the Reconstruction Congress proposed the 14th Amendment, promising all U.S. citizens equal civil but not political rights. In practice, however, these rights were denied or abridged by state laws and practices for nearly 100 years and didn't begin to become meaningfully available to African Americans until after the Civil Rights Movement of the 1960s. The framers and ratifiers of the 14th Amendment expected that civil rights would be defined and enforced primarily by Congress, not the courts, but the courts high-handedly insisted on their own supremacy, denying Congress the right to interpret civil rights more expansively. When the Civil War ended, it was Congress, not the courts, that attempted to extend equality rights after Southern states passed the notorious Black Codes, restricting the rights of freedmen to own property, to make contracts, and imposing discriminatory punishments. In 1866, the Reconstruction Congress passed the Civil Rights Act, designed to repudiate the black codes and guaranteeing all persons equal rights to make and enforce contracts, to sue and be sued, to inherit property, and so forth. Because of doubts about whether Congress had the constitutional authority to pass the Civil Rights Act, Reconstruction Republicans in the 39th Congress proposed the 14th Amendment to the Constitution, which was ratified in 1868. I'm going to read the first section, and I want to read it from my National Constitution Center pocket constitution, which I can give to you, and I urge you to ask me for, because I'm trying to distribute these. I can read it if I hold it far away, tragically, but here's section 1 of the amendment. I could try to, I won't try to, I can do the Fourth Amendment by heart. Let's see how I do. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall enforce any, well, no, I'm not going to, that wasn't bad for the first sentence. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person within its jurisdiction of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That inspiring section is the basis of most of our contested debates over the meaning of equality for the past 150 years. What was Section 2 designed to achieve? At the very least, the Privileges and Immunities Clause of the 14th Amendment was designed to give constitutional protection to the rights protected in the Civil Rights Act of 1866, namely the right to make contracts, the right to be sued, and so forth, and to prohibit the states from denying or abridging these rights. The principal drafter of the 14th Amendment, John Bingham, this is the James Madison of Reconstruction, also believed that the privileges and immunities of citizens of the United States included most of the basic rights enumerated in the Bill of Rights. So you understand the stakes here. Originally, the Bill of Rights applied only to Congress. It says, Congress shall make no law abridging the freedom of speech. John Marshall confirmed in the famous Barron and Baltimore case that only Congress was bound by the Bill of Rights. But John Bingham and many of his colleagues fought the Civil War in order to apply the Bill of Rights against the states and to ensure that the states and the federal government had to respect these basic rights of equality. Some of them, incidentally, thought that states were implicitly prohibited from abridging basic rights even before the Civil War. They viewed the comity clause of the original Constitution, the Privileges and Immunities Clause, as essentially guaranteeing fundamental rights of United States citizens to all people when they travel from one state to another, but they recognized that this was implicit, not explicit, and they acknowledged that the 14th Amendment was necessary to give Congress the power explicitly to prohibit the states from abridging basic rights of citizenship. Now, it's not clear that all the states that ratified the 14th Amendment, and of course, remember, this ratification was achieved at gunpoint in some cases. The states were not allowed to be readmitted to the Union unless they agreed to ratify the amendment. Some of them may not have agreed with Bingham's expansive view. And therefore, the precise scope of the 14th Amendment was an open question when the Supreme Court first attempted to define it in 1873. The court's first encounter with the 14th Amendment in the slaughterhouse cases was not auspicious. In fact, the late Robert Bork acknowledged that everyone agrees that the slaughterhouse cases was wrongly decided. Liberals and conservatives converge around this point. And the reason it was wrongly decided was because it read Bingham's Privileges or Immunities Clause and the equality guarantees of the 14th Amendment out of existence, basically on pragmatic grounds. The justices were afraid that a broad reading of the Privileges or Immunities Clause would turn the court into a perpetual censor on state laws, so the justices proceeded to pretend that the clause didn't exist. Requiring the states to respect the privileges or immunities of national citizenship would, quote, fetter and degrade the state governments by subjecting them to the control of Congress, the court held. And therefore, the court would refuse to do so in the absence of language which expresses such purpose too clearly to admit of doubt. This means that if Congress wanted to force the states to respect the Bill of Rights, it would have to say so clearly and unequivocally. In fact, Bingham thought he was being as clear and unequivocal as possible. A few years after the 14th Amendment was passed, he stood up in Congress and explained how he had read John Marshall's famous case of Barron and Baltimore and said that if Congress had wanted the states to have to respect the basic rights in the Bill of Rights, it would have said so explicitly. And Bingham said, following the Chief Justice's language and following it to the letter, so I did ensure that the majestic language of the original Constitution, no state shall, which was the word that the original Constitution used to prohibit deprivations of fundamental rights, was incorporated into the 14th Amendment. So Bingham thought he was choosing his language explicitly, but the Supreme Court, in a cursory opinion that's now regarded as ahistorical and unfaithful to the text and original understanding of the 14th Amendment, ignored that noble aspiration. Like the Dred Scott case, the Slaughterhouse case is a cautionary tale about the dangers of judicial unilateralism, by which I mean an attempt to impose a contested vision of a constitutional provision in the face of vigorous disagreement to the contrary. Although there may have been plausible disagreement in Congress between 1868 and 1873 about whether the 14th Amendment incorporated all the restrictions of the Bill of Rights against the states, there was little disagreement that it prohibited the states from passing either class legislation, that is legislation that took property away from A and gave it to B. It was basically an anti-monopoly principle, and the framers of the 14th Amendment were very concerned with monopoly power and with giving large corporations power to thwart their small business competitors. And the framers were also concerned with the anti-caste principle, C-A-S-T-E. Thaddeus Stevens stood up in Congress and said, this is designed to eliminate caste legislation, legislation designed to degrade or stigmatize on the basis of race. So for the Supreme Court to substitute its own cramped vision of federally protected rights for the far more generous vision of Congress was unilateralist in the extreme. But then things got worse. The Civil Rights Act of 1875 was passed by a lame duck Republican Congress, which had just lost control of the House because of its liberal views on race. The Civil Rights Act of 1875 was the crowning achievement of Charles Sumner, the Massachusetts abolitionist who had devoted its life to his passage. He wasn't able to incorporate in the final text of the act a requirement for desegregation of schools, although he believed that that was a basic civil right, but the act did prohibit discrimination in places of public accommodations, streetcars, railroads, and so forth. And Sumner, literally on his deathbed, the vote was pending, and his last words were essentially, my bill, don't let them forget my bill. And then he expired. And this, he believed, would finally vindicate the promise of the 14th Amendment and ensure equal civil rights in places of public accommodation. And yet the Supreme Court struck that act down, and it did so on cramped grounds, embracing a vision of Congress's power far more limited than that the framers of the 14th Amendment themselves embraced when they, in Section 5 of the amendment, which gave Congress the power to enforce the 14th Amendment by appropriate legislation, anticipated that Congress would be the primary enforcer of rights, not judges. Rather than indulging in judicial heroics, the court could have attempted to do no harm, simply getting out of Congress's way and enforcing the few Reconstruction-era laws which were designed to guarantee equal civil rights for African Americans. Instead, they struck down the Civil Rights Act in the civil rights cases. This is 1883. The high water mark of liberal Reconstruction and the Civil Rights Act's guarantee of full and equal access to public accommodations in inns, trains, ferry boats, and theaters attempted to make the 14th Amendment a reality. But the political climate had changed. The Republican majority in Congress had been voted out of office when it passed the Civil Rights Act, and in the contested election of 1876, which prefigured in the most eerie and remarkable ways imaginable the contested election of 2000, right down to the fact that in 1876, as in 2000, there were dueling slates of electors for the Republican and Democratic candidates emerging out of the state of Florida. Southern Democrats agreed to abandon their support for the Democratic candidate Tilden and threw their support behind his Republican opponent Hayes, and in exchange, Democrats demanded the end of Reconstruction. Justice John Marshall Harlan wrote a fiery dissent, and the story of his dissent is remarkable. He had a writer's block. He couldn't think of exactly what to say, and his wife noted that he was struggling and saw that at the Supreme Court, the curator had the actual inkwell that Roger Taney had used to write the Dred Scott decision. So one day when Harlan was at church, as he virtuously was most Sunday mornings, Mrs. Harlan took the inkwell and placed it on his writing desk, and Harlan got home and saw the inkwell that Tawny used to write Dred Scott, and he was seized by a kind of divine inspiration and took his pen and wrote his dissent in one energetic draft. He felt like his role was to efface the stain of Dred Scott and to write a dissent that would be vindicated by the ages. And it took nearly more than a century. It took the Civil Rights Act of 1964 to vindicate Harlan's hope, but it was indeed vindicated. And in his prescient dissent, Harlan wrote that Republicans since the Reconstruction era had considered exemption from race discrimination in respect of any civil right as the preeminent privilege or immunity of United States citizenship that the 14th Amendment meant to protect against state infringement. And it was plausible, Harlan said, to consider railroad owners and keepers of inns and restaurants as agents of the state because they're charged with public duties and amenable to government regulation. For this reason, Harlan concluded, equal access to these quasi-public facilities should be considered a basic civil right on par with the right to make and enforce contracts. And because of the court's decision to substitute its own cramped vision of federal power for Congress's vision, advocates of equal rights had to wait until the civil rights era of the 1960s until they could again persuade Congress to prohibit discrimination in public accommodation. So this is a dramatic example of judicial activism, of the courts substituting its own cramped vision of equality and federal power for those of the original understanding of the 14th Amendment, and it is a case that does not redound to the court's credit. The courts also played an unhappy role in the elimination of African American suffrage. The Supreme Court refused to enforce the few federal protection for African American voting rights that had survived Reconstruction. In the Reese case from 1876, it struck down sections of the Enforcement Act of 1870 that prohibited discriminatory administration of voting qualifications by state officials. And in the early 20th century, after the congressional commitment to Reconstruction collapsed, the court upheld various state efforts to disenfranchise African Americans that violated even some of the narrowest original conceptions of the 15th Amendment, which guarantees African American suffrage. In the most dramatic confession of judicial impotence in the face of local intransigence, the court in the GILES case from 1903 refused to stop Alabama's massive and successful efforts to disenfranchise qualified black voters. White voters who'd registered before 1903 were considered registered for life, while African American voters who applied after that date were subjected to a series of more severe tests. In his opinion for the court, Justice Oliver Wendell Holmes, who's come down in history as a progressive hero, but in fact was an aristocratic nihilist of the most enthusiastic description, so cynical about justice after the Civil War, where he was thrice wounded, that he once said, "If my fellow citizens want to go to hell, I will help them. It's my job." Even as he said, "I loathe the thick-fingered clowns we call the people." So Holmes, there's a gasp at that robust expression of sort of Nietzschean indifference. He was a nihilist of the most enthusiastic type, and his judicial philosophy was one of total abstinence. Basically, he would basically never strike down laws because he believed that majorities had to be able to crush minorities at the voting box, or else open war would break out. That was the dark lesson he took from the Civil War, where he'd marched off. His mother was an abolitionist. He'd been full of enthusiasm for the Northern cause, and after seeing the carnage of Antietam, where he was wounded and almost died, 17,000 men died, 23,000 died or wounded, the bloodiest day in American history, Holmes lost his faith in abolitionism and in all ideals, and basically believed that the strong had to crush the weak politically, and courts had to get out of the way. That was his judicial philosophy. And it was never on more perverse display than in this Giles case, where he did not dispute that, as he put it, this refusal to register the blacks was part of a general scheme to disenfranchise them. He acknowledged that. But then he invoked this perverse catch-22. He said, even assuming the whole registration scheme of the Alabama Constitution is a fraud upon the Constitution, the court couldn't attempt to correct it without becoming a party to the unlawful scheme. The odd implication was that the court was powerless to correct even clearly unconstitutional efforts to subvert the law. And then Holmes noted with bracing candor that the courts didn't have the practical ability to enforce political rights in the face of the determination by a great mass of the population to keep the blacks from voting. And he concluded with a flourish, if the conspiracy exists, a judicial decision would be powerless to defeat it. Instead, relief from a great political wrong must be given by the political process itself. That's judicial abstinence on steroids, really. So the Giles case is perhaps the starkest confirmation of Holmes's judicial philosophy, which holds that the law should conform to the wishes of the dominant majority in any political community, despite the text and original understanding of a constitutional amendment to the contrary. Holmes's opinion was hard to reconcile with the constitutional judgment of Congress that passed the 15th Amendment, which enfranchised African Americans. Although Congress in the 1890s showed little enthusiasm for enforcing the 14th Amendment's penalties for states that refused to enfranchise blacks, it declined to pass proposals by Southern representatives and senators to repeal the 15th Amendment entirely, and there were terrible feedback effects of the Giles decisions when defenders of African American suffrage called on Congress to refuse to seat representatives from states that disenfranchised blacks. The House Committee on Elections declined the invitation, claiming it was deferring to the judgment of the court. During the Progressive Era, it's true that the Supreme Court was not completely impervious to the arguments of disenfranchised blacks. In the Gwynn case from 1915, the court struck down the Oklahoma grandfather clause that offered an exemption from literacy tests only for those citizens who'd been on the rolls in 1866 when no blacks were eligible. But it wasn't until the 1940s that a more favorable political climate helped the Supreme Court to increase African American suffrage by invalidating white primaries in cases like Smith versus Allwright from 1944. And the political context is crucial here. Black servicemen returning from World War II who had fought side by side their white brethren were more determined to demand their rights. Southern whites were less determined to resist. Jackie Robinson is about to integrate baseball. The US government is being criticized from Russia and from abroad for forms of American apartheid. The Roosevelt and Truman administration are beginning to throw their weight behind civil rights, and federal prosecutors are more willing to threaten resistors with prosecution. So as a result of this favorable political climate, Southern judges could be persuaded to construe voting rights broadly rather than narrowly. And this sets the stage for Brown versus Board of Education. As I began by noting, we think some of us are taught in civics class or even in first-year con law, if we go to law school, that Brown is an example of the heroic judges resisting the political wind and enforcing equality in the face of majority resistance. That's not quite right. The political winds were shifting, as I described. Both the White House is in favor of desegregation. Congress would be in favor of desegregation if it weren't for the lock hold that Southern Democrats had on the committee system. So a minority of Southern Democrats are able to prevent the Republican and Northern Democratic majority from adopting desegregation. And most important, the polls are shifting. National opinion about public school segregation in 1954 found approval by more than half the country. 54% of the country, when Brown was decided, actually favored desegregation. So this was not a case of the court imposing a minority view in the face of majority resistance. There was constitutional ambiguity, decent arguments that the framers of the 14th Amendment did not intend to prohibit school segregation, but also plausible textual and arguments on the other side. And the argument on the other side essentially was this. The framers of the 14th Amendment were determined to prohibit caste-affirming legislation designed to stigmatize and degrade blacks. Segregated schools were designed with the purpose and intent of stigmatizing and degrading blacks, as Charles Black, the great Yale Law School professor, observed soon after Brown. Everyone knows that the purpose and intent of segregation was to stigmatize and degrade, and anyone who denies that common knowledge should be greeted with the sovereign prerogative of philosophers, namely laughter. That's what Black said, that although the question is contested and there are thoughtful liberals like Judge Learned Hand who thought there was no basis to strike down segregation because the original understanding wasn't clear, but Black cut to the chase and said, everyone knows what's going on here. In doing so, he invoked, Charles Black did, Justice Harlan's famous dissent in Plessy versus Ferguson, when Harlan, alone in dissenting from the court's decision to uphold railway segregation in the 1890s, basically says, I grew up in Kentucky, I know what the purpose of this segregation is. Everyone knows that the purpose was to stigmatize and degrade. And that everyone knows argument was not embraced by the court until 1954, and even Warren didn't make it explicitly. He relied on contested statistical studies showing the effect of school segregation on African American children that were later contested and gave recalcitrant Southern judges and states opportunities to resist Brown. The story of Brown, of course, is a riveting story of constitutional history. Brown was first argued in 1953. The Chief Justice's Vinson, President Truman's sort of dog-faced poker buddy, a former senator, hard drinking, not respected intellectually by his colleagues. Felix Frankfurter condescended so much to Vinson that during one conference, Vinson threatened to punch Frankfurter in the nose. But all of a sudden, and there's a vote on the first time over Brown versus Board of Education, and there's a narrow majority to uphold school segregation. And then all of a sudden, Vinson dies. He drops dead. In the funeral train on the way home from Vinson's funeral, Frankfurter remarks, "This is the first indication I've ever had that there is a God." Not a kind thing to say. But for better or for worse, and for better, in the case of Justice in America, Earl Warren was appointed to replace Vinson, the former governor of California, moderate, pragmatic Republican, supervises the conference. The vote is taken again. There's a majority to strike down school segregation, but a few holdouts, including first Justice Robert Jackson, the most beautiful writer in the history of the court, who, despite his commitment to racial equality, just didn't think that text, history, and precedent supported Brown. But he's persuaded on pragmatic grounds to uphold, to vote with Warren, and comes from his hospital bed. He dies soon later of a heart attack to cast his vote. And then there's one final holdout, Stanley Reed from Kentucky, and Warren says to him, it's going to be bad for the court and bad for the country if you alone are dissenting here. Reed decides to go ahead, and when Warren reads the unanimous decision to a spellbound courtroom, Thurgood Marshall looks up at Reed and says, "You, Stanley Reed, have voted for this decision?" And Reed nods down and says, "I voted for it." Just this electric moment. So that's the Brown case. And it deserves to be celebrated as a high water mark of the Supreme Court's commitment to vindicating the promise of the Reconstruction amendments. But in practical terms, it has to be said, neither Brown itself nor the embattled efforts of a few Southern judges made much immediate difference in desegregating the schools. In 1964, 10 years after Brown, scarcely more than 2% of African American children in the South attended desegregated schools. By contrast, in the following decade, Southern desegregation accelerated at an impressive pace. By 1971, 44% of black students attended majority white schools in the South, compared to only 28%, interestingly, in the North and West. What can account for this transformation? Essentially, the civil rights movement. The Freedom Riders, the Civil Rights Act of 1964, Title VI of which prohibited the distribution of federal funds to any federal program that discriminated on the basis of race, and the executive's enforcement powers. It was around 1965 that the Justice Department committed itself to suing Southern districts that declined federal aid. And in 1966, this is the crucial moment, the Department of Health and Education and Welfare issued new guidelines interpreting the Civil Rights Act to require effective desegregation. At that point, lower courts were able to use the new guidelines to announce elaborate desegregation plans that applied to every school in their districts. In other words, it wasn't Brown itself, but the political transformation that followed it that made its commands a reality. Similarly, it wasn't until the passage of the Voting Rights Act of 1965 that African Americans in the rural South became meaningfully enfranchised. Congress abolished literacy and good character test, authorized federal officials to supplant local officials who refused to register blacks, a decision that the president backed with federal force. So I've argued in this brief tour of the Supreme Court's decision regarding equality and voting rights that Congress, not the Supreme Court, has tended to take the lead in expanding voting rights and civil rights. And when the Supreme Court has invalidated federal or state laws in the names of hotly contested visions of equality, it's tended, with the benefit of hindsight, to thwart equal rights rather than advancing them. What does that say about the constitutional debates that are riveting the country today involving the future of affirmative action and voting rights? This is a discussion I'd like to have with you in our dialogue, but let me just set the stage for this decision, for this conversation by saying that I'm not going to weigh in on the merits of cases like Seattle school districts from 2007, which struck down affirmative action plans in Seattle and Louisville public schools, or the Shelby County case from last year, which struck down parts of the Voting Rights Act of 1965, or, just last week, the Schuette case, which upheld the Michigan Civil Rights Initiative that forbids states from discriminating or granting preferences on the basis of race. There are, I know every day at the National Constitution Center, strong constitutional arguments on both sides of these cases. Often they boil down to the question of which vision of the 14th Amendment you embrace. Do you regard the 14th Amendment as a requirement of color blindness in all circumstances and a general prohibition on all racial classifications? Or do you view the 14th Amendment as prohibiting only those racial classifications designed to stigmatize and degrade? As I say, there are strong textual and at least textual arguments on both sides of these positions, and I'm not going to choose among them. But I do want to invoke the history that I've just reviewed with you today to suggest that the court should be cautious about striking down laws involving racial equality, and more cautious about striking down those laws than upholding them. And in this sense, I think that Justice Breyer's concurrence last week in the Schuette case is especially instructive. In Schuette, the plurality, Justice Kennedy and Chief Justice Roberts and Justice Alito, upheld the Michigan Civil Rights Initiative, where Michigan voters, responding to the Supreme Court's 2003 decision upholding affirmative action, forbade state officials from discriminating or granting preferences on the basis of race. So you understand what happened? Remember, there's Grutter and Gratz in 2003, and the Gratz case strikes down affirmative action at the University of Michigan. The Grutter case upholds affirmative action at the University of Michigan Law School. Michigan voters don't like that, and they pass an initiative by state referendum saying that you can't discriminate or grant preferences on the basis of race. And the question before the court in Schuette is, does that initiative itself violate the political process rights of African American voters by making it harder for them to, for supporters of affirmative action to enact their policy preferences? They have to go to the state voters as a whole and get a constitutional amendment, whereas everyone else can just go to the legislature in order to make their case. The plurality opinion written by Justice Kennedy stressed the importance of judicial restraint in cases like this one, where citizens, including minority citizens, vigorously disagree about whether the policy in question is likely to harm minorities or help them. In the face of democratic disagreement, Kennedy and Chief Justice Roberts and Justice Alito held, the court should practice judicial restraint and defer to democratic decision-making. In his concurring opinion, Justice Stephen Breyer agreed with his more conservative colleagues on this point. And in my view, Breyer's concurrence is supported by the constitutional history I've outlined today. Justice Breyer enthusiastically defended the importance of letting democratically accountable bodies decide whether affirmative action should be adopted or rejected. Democratically unaccountable teachers and administrators, he stressed, had adopted Michigan's affirmative action ban, and this distinguished the Michigan ban from the Seattle affirmative action plan that the court had struck down in 2007, a decision from which Breyer wrote a vigorous 77-page dissent. As Breyer wrote in the Schuette case last week, the Constitution, quote, favors decision-making through the democratic process, just as this principle strongly supports the right of the people or their elected representatives to adopt race-conscious policies for reasons of inclusion, so it must give them the right to vote not to do so. And I think that if the court had remembered this lesson throughout the 19th and 20th centuries and been more restrained and allowed Congress, rather than judges, to define the contours of equality, then African Americans would not have had to wait until the 1960s to claim the equal civil rights and voting rights that the framers of the 14th and 15th Amendments had promised nearly a century earlier. Thank you so much, and I'd love to have a discussion with you about these fascinating questions. I am a law professor, and I have some former students in the room, so I can call on you. Yes, sir.
I live and vote in the District
Yes,
of
ma'am.
Columbia,
Sorry.
has no congressional voting rights the white man to environmental respect. To me, this is the same issue of why it matters and what we can do about it. And I maintain it's not only not healthy for us as the internalized colonialism, it isn't healthy for the rest of the country in all kinds of ways. To be comfortable with it and allow it. What do you think about it? Does this infuse your thinking every day? I think it should. And what can we do about it in D.C. and with the 3 million Americans who have senators? Because I think at the core of our country is in trouble. If we don't pay attention to this, taxation without representation begins at home. And does that infuse your thinking and the thinking of your colleagues? I'm a big Mary Chase fan, frankly. I live in Washington.
Thank you so much. I'm Mary Chase fan too. She's my colleague at GW Law School, and as it happens, this does infuse my thinking every day. I wake up every morning thinking about the Constitution, and this is the question you've identified as one of the most interesting of constitutional questions involving voting rights. Let me put on my National Constitution Center hat and just, try to neutrally describe the arguments. And I think I would say, and I was on a great panel on this question, where Ken Starr, in fact, the president of Pepperdine University, he's an enthusiastic proponent of DC voting rights for some of the same reasons that you've just identified. But the bottom line is that obviously the Constitution does not protect DC voting rights. And if they are to be protected, they probably will have to come by statute. And if a statute is to be passed, it'll have to involve some kind of compromise. And the compromises that are on the table are that DC might get a representative in exchange for a red state getting a representative. You don't like that idea, but in practice, this is sort of the way that it's likely to happen. But imagine that even this compromise, which in these polarized times occurs, and a DC voting rights bill is passed by Congress. It would go up to the Supreme Court, and the question would be, does Congress have the power to guarantee voting rights along these lines? And there are strong arguments being raised by opponents of DC voting rights that Congress would lack that power. And the history that I've suggested today suggests that judges should take, once again, the most deferential and restrained view of their powers when it comes to evaluating questions involving fundamental voting rights and equality notions. And as long as there's a plausible constitutional argument for upholding the stated assertion of congressional authority, judges should defer to Congress rather than substituting their own wisdom. So I think that's where we stand, given the difficulty, as you know, of passing a constitutional amendment.
Well, in the end, I think we should have a clear constitutional amendment, but the way to get there is to say this is not okay, this is not the answer, and why it's not the answer is everybody's business, everybody loses when we have no voting rights, why do we family respect?
It's so interesting. I had the privilege, Justice Stevens came to the National Constitution Center on Monday. He testified here on the Hill yesterday, and he has a new book out called 6 Constitutional Amendments. And they basically have to do with government neutrality. Justice Stevens' whole career has been appalled by state officials putting their thumb on the scales. So his amendments include a ban on partisan redistricting and a constitutional amendment that would create a nonpartisan commission to draw electoral districts. He does think that reasonable restrictions on campaign finance should be allowed by constitutional amendment. He doesn't like bans on sovereign immunity that prevent citizens from suing states in order to enforce their rights. But I think that his vision that neutrality can only be achieved by constitutional amendment is quite provocative. One thing that really struck me about Justice Stevens, who is a marvel. He turned 94 last week. He celebrated by playing tennis this weekend. We all should. He's a force of nature, but he's also an optimist. And he was asked, "So, do you think that these amendments going to pass? It's really hard to pass an amendment." He said, "I really have faith in the citizens of America, and I think when they hear my arguments and realize that rationality and fairness require these amendments, they will pass them." So, here on Law Day, I think I'd like to just note that optimistic faith in the power of rational deliberation, and let's hope he's right. All right, time to. Sorry about this, but we studied Justice Harlan together, the second Justice Harlan, not the first Justice Harlan, and the second Justice Harlan was an opponent of some of the extension of voting rights under the 14th Amendment, because he stressed that the 14th Amendment was originally intended to protect only political rights, not civil rights, and he didn't like decisions like Baker versus Carr, which imposed one man, one vote, because he said the court was essentially regulating political rights through the 14th Amendment, which it was never attempted to do. This is totally not fair, but I only can do this because we had such great time today in class. What, on reflection, I know you had strong views about Justice Harlan in general. What would he have made of this general question of equal voting rights, and do you think he was correct?
I think he was a big proponent of the democratic process. And I think, in the end, I think he agreed with Brookings that we, all things being equal, we defer to the democratic process. We don't have judiciary approaches to like a contrary views.
I think that's exactly right. That was the core of his dissents. But you were not crazy about that at the time.
I think, I don't know if you were positive or negative. I think it would be interesting to have somebody like Justice Harlan or President of the court today and see what his viewpoint would be in the wake of new evolving rights for the 14th Amendment, things like the evaluate the situation. What I'm curious about is we have these cases, shooting cases coming up last week, whether this pro-democracy vibe, for lack of a better word, is coming out from Justice Breyer's concurrence. What that means in the wake of this slew of decisions like the American decision for striking down democratically elected bodies who are voting to ban gay marriage, what that means in the wake of fundamental rights.
What a fascinating statement, and you so nicely tied together the two strands of Justice Harlan's jurisprudence and really tee up the basic constitutional challenges ahead for the court. So first, you said Harlan was certainly a proponent of liberty rights, and he wrote a celebrated concurrence saying that there was a right to be free from bans on contraception because the right of married couples in a home was protected by the Liberty Clause of the 14th Amendment as well as by the 4th Amendment. He said that he wasn't calling into question bans on abortion or restrictions on marriage, but you wonder whether that evolving constitutional vision that he had might have been extended to recognize gay marriage. And then you ask, how is that trend in the court that Justice Kennedy embraces, how can it be reconciled with the pro-democracy strand? So we see these two strands converging with riveting drama in the person of Justice Kennedy himself, who's at the center of all these cases. On the one hand, as you suggested, Kennedy writes the inspiring, I'm at the National Constitution Center, and I'm totally nonpartisan. Kennedy writes the important decision in the Windsor case, striking down parts of the Federal Defense of Marriage Act on the grounds that laws that are intended to stigmatize and degrade gays and lesbians cannot survive. And Justice Scalia objects, the logic of this decision means the end of bans on gay marriage. And Justice Scalia, remember, had made a similar prediction when Justice Kennedy struck down sodomy laws in 2003 in the Lawrence case. Scalia said, make no mistake, this is going to lead to gay marriage. And people said, no, don't be silly, you're overreacting. He was right. So, because the logic of the case does lead there. On the other hand, you have in the Schuette case, it's not just Breyer who defended the importance of deference to democratic decision-making. Kennedy, at the end of his plurality decision, has, well, here I will say it's inspiring because I've defended the pro-democracy view. He quotes the Declaration of Independence, he quotes the First Amendment. He said it's really important that citizens should be able to disagree on fundamental questions of public policy, and the court should generally defer to those decisions. That pay-in to democratic deference, as you suggest, is both hard to reconcile with the decisions striking down bans on gay marriage, and also with his decisions striking down affirmative action in Seattle and at the University of Michigan itself. So we've identified two big themes here that at the core of the struggle over voting rights and civil rights for the past century. One, a concern, at least more recently, with deference to democratic actors. The other, this powerful concern with striking down laws that stigmatize and degrade, and how exactly they're recognized will determine the future both of gay marriage and of affirmative action. So thanks for that. I'm glad I called on you. Hi.
You use the terminology of democracy or democratic in various types of
Thank you for that excellent question. You're quite correct that democracy is both a contested and rich term, and I have used it in different contexts. The broadest sense in which I was using it was the Supreme Court's deference to laws passed by Congress, the states, and local institutions, basically not striking stuff down when it's passed by democratic bodies. And that seems to me the most neutral definition of judicial restraint. It's not saying whether a particular decision is good or bad. Sometimes it's good to be activist if the First Amendment protects flag burning, then a law banning flag burning should be struck down. But deference to democratic decisions is one definition of democracy. But as you say, there are different levels of democratic decision making, and you could have a situation where one body, say the Seattle School Board, which is democratically accountable, favors affirmative action, but hypothetically, the citizens of the state of Washington as a whole in polls might not favor it. And this is your question. Since I've endorsed Justice Breyer's theory of democracy, it's a question as much for him as for me. The objection to his dissent in the Seattle case might be, why choose the lowest level? The school board is the level you're deferring to. Why not look at the broader body? Your question is all the more interesting, and now we're getting a bit into the weeds, but these weeds were at the center of the Schuette case. So let's see if we can describe the political process doctrine. This is important. It's important. The political process doctrine, as defined by cases from the 1960s, said that when a locality passes a busing ordinance, it says you've got to bus school kids to achieve racial equality, then the citizens of the state as a whole pass a referendum and say no legislature or judge is allowed to mandate busing. The Supreme Court, in a series of cases like Hunter and Erickson and so forth, said that statewide referendum violates the political process rights of minorities because it makes it harder for people who support busing, in particular minorities, to achieve their policy goals. They have to pass another state constitutional amendment, whereas everyone else who opposes busing can just go to the legislature. And the crucial language was, when a particular state referendum overturns a law that inures to the benefit of the minority, then it's suspicious under this political process doctrine. What was so striking about the Schuette case is it didn't invoke this doctrine, because it's clear Justice Scalia and Thomas in their concurrence in the Schuette case said, this is basically an argument against the entire referendum system. Anytime the citizens of the state as a whole decide to favor one side of a policy debate over another, they're favoring some people and not favoring others. And if you're going to say anytime you change the level of decision making in a case involving race or anything else, you're basically saying you can't have statewide referenda. You have to decide everything at the legislative or local level. Supporters of popular democracy would say that doesn't make any sense, that the views of the citizens of the state expressed through referenda has even more democratic legitimacy than that of a legislature, and that of maybe the state legislature more legitimacy than the local one. But, and that's what Scalia and Thomas seem to be suggesting. Justice Sonia Sotomayor, in her incredibly powerful concurrence, one of the most important of her career, rejected that view of democracy that I just described and said that given the reality of the history of race in this country, in her dissent, if you have some time, read this as a continuance of your celebration of Law Day and the history of voting rights and civil rights, because she says, with greater specificity and sophistication than I have, every time Congress or states attempted to extend voting rights to minorities, they were thwarted by the courts. So she says in practice, it's necessary to have protection for minorities from the political process, and therefore she would maintain and in fact expand this doctrine that says that there's something special about laws that harm minorities and they have to be subject to special judicial scrutiny. The counter argument, though, is it's a very contested question about whether affirmative action harms minorities or helps them. Justice Sotomayor famously in her book says it helps minorities and it helped me. Justice Thomas famously in his book and his opinions says it harms minorities and it harms me. So Justice Breyer and the plurality say, look, these are both plausible positions. They're policy arguments. They're not constitutional arguments. Whether affirmative action is good or bad for minorities is a policy argument. The court should not take sides, and the voters should be free to choose one side or another. Sotomayor disagrees. I think that's my answer. It's a complicated question, and it's at the center of this debate about the meaning of democracy the court is now engaging. Thank you for that. This is a very important question raised by the brain trust responsible for making decisions like this about the scope of Congress's constitutional authority. And the question is, to translate for the non-lawyers, I made an argument that when Congress passes law under the 14th Amendment, it deserves special deference, because Section 5 of the 14th Amendment says Congress shall have the power to enforce this article by appropriate legislation. And I think basically liberal and conservative legal historians agree. Michael McConnell, the most distinguished conservative legal historian, former judge on the 10th Circuit, says the framers of the 14th Amendment in particular really expected Congress to take the lead in defining rights of equality and expected the judges would give them deference. Your question is, does Congress get similar deference when it's legislating not under Section 5 of the 14th Amendment, but under Article 1, which gives it the power to regulate interstate commerce? And non-lawyers will remember the dramatic debate over the scope of the Commerce Clause that arose in the Affordable Care Act, when supporters of the constitutionality of the Affordable Care Act said that because the decision to buy health insurance or not to buy it will have huge spillover effects that will raise health care for everyone else if you're not insured, then it definitely is a regulation of interstate commerce to require people to buy health insurance. Opponents said the decision to not buy health insurance, like the decision not to buy gym memberships or broccoli, is a form of economic inactivity, not economic activity, and therefore is not covered by the Commerce Clause. As it happens, 5 justices, including Chief Justice Roberts, agreed with the second position and said that because the decision not to buy something is a form of economic inactivity rather than activity, Congress does not have the power to regulate it under interstate commerce. Roberts then said that nevertheless Congress could pass the Affordable Care Act under its taxing power. So I guess then the most recent Supreme Court precedent on the Commerce Clause tells us that courts, or at least the Supreme Court at the moment, the majority of the Supreme Court, is not going to be especially deferential to Congress when Congress very clearly asserts its own interpretation of the scope of its commerce power and will make what the dissenters considered quite close and rigorous scrutiny and be willing to second-guess judgments about the practical effects of a particular decision. So just descriptively, I guess if I were saying, imagining what I think the Supreme Court would do, they don't seem to be in a very deferential mood when it comes to the scope of Congress's commerce power right now. On the other hand, they're not in a very deferential mood when it comes to the scope of Congress's Section 5 power either. And although I talked about the importance of judicial restraint when it came to the 14th Amendment and also the Voting Rights Act, the Supreme Court in the Shelby County case refused to defer to the decision of Democrats and Republicans in Congress in a law signed by President George W. Bush, a big bipartisan law passed by big bipartisan majorities, that it was necessary to renew the covered jurisdictions under the Voting Rights Act because of the lingering effects of racial discrimination. So although I've tried to argue today that history suggests the wisdom of judicial deference when it comes to congressional assertions of its power under the 14th and 15th Amendments, I think you could again say descriptively that the Supreme Court has not adopted a similarly deferential attitude. And I think with those words, I've delighted you long enough, ladies and gentlemen. Thank you for the honor of talking to you on Law Day. Thank you very much.
All right, thank you again, everyone, and thank you, Professor Rosen, for that very thoughtful and very balanced presentation for us. I just want to thank you again for coming and also mention a couple of things that we have coming up. As Professor Rosen mentioned, we have a huge Magna Carta celebration coming up next year. It's the 800th anniversary of Magna Carta, and the Library of Congress will be sponsoring an exhibition to open November 6th of this year, where we are having the privilege of having one of the 4 existing copies of original 1215 Magna Carta on display here, along with treasures from our collections. And so I hope you will all stay tuned for that very important anniversary as well. And leading up to that, we will be sponsoring a whole bunch of programs related to Magna Carta starting sometime this summer, I believe. So if you follow us on social media or if you watch for our announcements some other way, please make sure you come to those programs. And lastly, I'll just mention our next program is scheduled for the first week of June. Former Congresswoman Schroeder will be here, and we will be interviewing her, and she'll be talking about her career as the first member of Congress from Colorado, her time as president of the American Publishing Association, and also now as a college professor. So we look forward to that, and I hope you join us then. All right, thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.